Before I get into the meat of our discussion today, I do want to give a disclaimer that this is for informational purposes only. This is not legal advice specific to your situation, since I don't know your specific situation. This does not create an attorney-client relationship between you and my firm. And again, if you want to talk further, I'm more than happy to schedule a consultation to discuss your needs. And without further ado, let's talk about protecting your business legally. So you may have heard of different types of business entities that you may choose to have. You may have an unincorporated business, which means that you don't have any filings with your state. That would be a sole proprietorship. That would be a partnership. So for a sole proprietor, all you have to do is be one person doing something for profit in the marketplace. And that classifies you as a sole proprietorship. In terms of a partnership, that's where two or more people come together and agree to embark on a set of actions geared towards making a profit. So again, you don't technically need paperwork for either of those forms. It's just the action doing it that creates the partnership. And there's a set of default rules that apply to partnerships and sole proprietorships. And they can be excellent vehicles depending on what kind of business you're in and how you're strategically set to operate, organizational structure, if you will. A couple things to know about those structures is that liability becomes an issue. If something goes wrong with the product that you've created and, God forbid, you're sued for that and there's a judgment against you, your personal assets would be collectible, if you will, your car, your personal bank accounts, if you're not properly set up, on the financial side, which we'll get into a little bit. Same with partnership. So without any additional vehicles for liability protection, you could be exposing yourself to some level of risk. Again, depending on what you're doing, the risk may be smaller, it may be great. So that's why a lot of entrepreneurs decide to go into a legal form, which requires filing with the state. So we're talking about LLCs, professional limited liability companies for certain professions. We're talking about corporations as well. And then there's a lot of little offshoots depending on the state. So these require state filing. For example, if you were to start an LLC in Virginia, you'd file your articles of organization with the state. You pay your $100 fee and you're pretty much good to go, as long as you continue to maintain what are called corporate formalities. So for LLCs, it's fairly simple. You have to pay your annual registration fee. It's $50 a year. Now, if you were to go the corporate route, you have annual statements that would have to be filed. You'd also have to file what's called the Articles of Incorporation, which is a little more involved because the corporate structure is inherently more complex than an LLC might be. Although you can have LLC structures that do get increasingly complex depending on, again, your particular needs, your particular operational structure. One thing about corporations and LLCs is that they do come with a certain level of liability protection. So as long as you are maintaining those corporate formalities, one of them would be not using your personal personal checking or savings accounts to transact business for your company. That's a big one. Making sure that you're doing the proper filings, making sure that you are doing what you need to do in terms of taxes. As long as you're doing those things, you'll be protected. What can happen is if a court finds that you're not maintaining those corporate formalities, they do what's called piercing the corporate veil, where they will determine that, okay, you're basically running this fraudulently, you're not maintaining the corporate formalities, and we're going to go into your personal assets. So again, finding a structure that works for your business. A lot of people go to LLCs. LLCs aren't for everybody. You need to really assess where you are with your business, what your long-range plans are, what your organizational structure is, and then match those with the right business vehicle that will best serve you. And there's also a tax side to that, how you're going to be taxed. And then, that can become complex too if you decide to be taxed as an S corporation, which is a whole other thing that can provide benefits if your business is in the position to take the best advantage of those benefits. So the bottom line with regard to business entities is that it's a highly customizable area, and it's very important to make sure that you pick a vehicle that serves your business. Again, LLCs are pushed on everyone because they're easy to start, but they're not necessarily easy to maintain if you're not equipped all the way around to maintain those corporate formalities. One thing also is that LLCs, many states have what's called a sole member LLC, so you don't need a second person to start them. What I find is a pitfall for sole members who form LLCs that way is that they don't have an operating agreement. An operating agreement is basically the blueprint for your business. How to add new members, how to get rid of members, how to increase your capital assets, all sorts of things that come commonly in the life of your business that need to be addressed. Many single member LLCs forego coming up with a comprehensive document that addresses all of these points, and can run into some issues down the road because they've not taken the time to do the forethought and the planning that goes into those things. And again, this is something that you have that addresses the life cycle of a business. Normally with a corporation, you have your bylaws. This is the same thing for an LLC, would be akin to your bylaws, where you'd lay out what happens. What happens if you decide that you don't want to run the business anymore, but you need to liquidate your assets? There's a whole bunch of things that need to go into that. And I always advise clients to do this up front so that you're not scrambling on the back end. Again, having those documents also show the public, or God forbid, again, if you're in a court proceeding, that you have taken the time to properly set up your organization. You're less likely to have your organization pierced and your personal assets at risk. Okay. So again, just to summarize that, it's really, really important to assess your needs, have your business plan, consult with the proper people, whether it be an accountant, if you need help with the business plan, somebody that specializes in that, and also an attorney if you need help setting up that legal structure. I want to move on to discussion of copyright. Copyright and trademark are two forms of intellectual property that sometimes get confused. So what I'll do is I'll describe what they both are, and then I'll delve into copyright first and then go into trademark. So copyright protects expression, music, television, books, magazines, articles, fashion designs. There's a whole bunch of different types of creativity that can go into what's protectable as a copyright. The main thing is this: it has to be fixed in a tangible medium. This is straight from the federal statute. So fixed in a tangible medium means that it's not just a thought. You cannot copyright an idea or a thought. It has to be fixed in some kind of way. So if you're writing an article, that would be the draft. If you were writing a song, that would be your lyrics. And I get asked a lot, well, what about if I don't have something tangible? We don't use CDs anymore. I might be dictating into my notes app. If you have it and it's saved even on a mobile device or an external hard drive or a thumb drive, that can be considered fixed in a tangible medium. You've got to have some evidence that you have memorialized that thought or that idea. So once you have that, you also have what's called, some people call it common law copyright, but you have a copyright. Once you fix that in a tangible medium, you really do have protection over that. The problem is nobody else knows that you've done that. The problem also is if somebody is infringing on your copyright, if you've not registered your copyright, then you have no standing to sue in court to stop someone from using or infringing upon your copyrighted material. So that's why registration is important. And registration, depending on what you have, again, this is highly dependent on the thing itself that's being copyrighted, but you would need to file online. So there's a website, eco.copyright.gov. That's where you go and you create an account. And it walks you through the steps to copywriting or applying for copyright registration. Now, again, depending on what type of work you have, the process may be simpler or more complex. So for instance, if I just had one song I was going to copyright and I was the only one who did anything on the song, I didn't collaborate with anyone, the process is relatively easy. You get into a more complex situation where you might have multi-volume works. So say you are in conjunction with your business, you've got a podcast series. So how you might choose to register that may, number one, cost you more money, or it may also just be more complex depending on the people involved. So for instance, you might decide to film or record a whole podcast season at a time and then copyright that as a volume. A multi-volume work is what that would be called, or you may do it one at a time. Now, again, for those, if you're creating a lot of content routinely, you want to group it because each application is going to cost you $55. So if there's any way that you can group something into a volume rather than a single work, you're going to save a lot of money in the long run. But there are caveats to that. So if you have different collaborators for each episode, you're most likely not going to be able to do that. Again, this is one of those nuanced areas of the law where you really want to make sure you understand what lane you need to be in order to properly register your work. Another thing about joint authorship, it's really important to think a lot on the front end when you are working in collaboration with others. And the music context, I guess, is one of the most clear examples of how that can be problematic. So say two people get together and one person writes the music, the other person writes the lyrics. The person who wrote the music wants to copyright their music. The lyricist wants to copyright their lyrics. And they think of them as separate entities. But if the two of them got together with the intention to create one work, you cannot separate the music from the lyrics. Therefore, the lyricist owns, in essence, half of the music and half of the lyrics. Same would be for the person who wrote the music. So you really have to think about what that ownership looks like. And what I'm describing here are default rules. So unless you have a collaboration agreement, you're going to be held to those default rules. And when you create those registration applications in the eco.copyright.gov system, they don't care about your contracts. That's on you. So it's up to you to make sure that you have that straight in case something comes up. There's another point that I wanted to make about that with joint works. It'll come back to me. Okay, also with joint works, if you're publishing something, publishing a book, publishing an article, you got to think about monetization as well in licensing. People who own copyrighted material have the right to license that work. So if you've written something, or if you're a podcast host, for instance, and you have a guest, and the guest, you've not clarified the understanding between what this collaboration is going to be, your guest may feel that they have the right to give permission for someone else to use your podcast and monetize that. Now, default rules, joint authors can have freedom to license to whoever. The only thing is that they have to split the proceeds in equal shares unless there's a contract. So this is also important where you're not sure that it's appropriate for other collaborators to unilaterally be able to enter or to encumber the copyrighted work in a license. For instance, if you had a joint collaborator that gave an exclusive license for the use of your copyrighted material, then you could not monetize that somewhere else. And that could potentially be a bad business decision. So again, copyright registration is like the tip of the iceberg, but you really need to make sure that you're thinking through if you're planning to monetize, if you're planning to publish, what that looks like. And I always tell my clients to plan for success. So if your goal is to monetize, you have to have a plan for what happens when the opportunity for monetization occurs. Again, if you have other questions about copyright, it can get very nuanced, so I can't address every little situation, but please, please, please do feel free to reach out, and I'll give my contact information at the end. I'm just trying to provide an overview so you are able to issue spot if you need to go that route in terms of registering something for copyright protection. Trademark. So trademark is, again, it's something that you can apply for federal registration. It is inherently more complex than the copyright process. Trademark is where you have words, phrases associated with the brand. So if you are offering goods or services and you have a brand name, trademark is the vehicle to protect that brand name. So that means that, for instance, if I'm selling shoes and I'm under the brand Nike, that means nobody else can sell shoes and call themselves Nike or anything confusingly similar to that. And the whole idea of having a trademark registry is to make sure that you don't have duplicate names or names that are too close in relation to where consumers looking for one type of product are being confused about the brand identity. And that is the main goal of having a national registry. Again, because it's a national registry and because these are really important rights, once you can secure them, the process isn't that easy. So again, the advantages of having federal trademark protection is that nobody can use that name in association with the same goods and services that you can. So let me give you a nuance about that point. So going back to the Nike example, if I wanted to use the name Nike for, I don't know, milkshakes, you might be able to do that because it's a completely different good than shoes or athletic wear. So what you'll see if you're delving into the trademark registration process is that the US Patent and Trademark Office divides goods and services into what they call international classes. Again, international classes is just a fancy term for a good or service. So you'll have to decide what goods and services you want or need to be covered by your trademark. It may be more than one, depending on your business. So that is a consideration. Also, it's a consideration because you have to pay a separate application fee per good, per international class. So if your brand is covering, let's see, say you're an educational company and you create books, but you also provide training services. Those are two different international classes. So you'll be paying a fee, and it went up this year. So on average, it's about $300 per international class that you'll be paying. So you have to kind of factor that into your budget, into your planning. Some people do everything up front, and depending on the type of application you file, you've got to do everything at one time. So again, this is really about digging into your strategy, looking into your long range projections and making sure that you're positioning yourself for the most appropriate level of protection. We'll say that. So once you've decided that you want to go forth and protect your brand in association with goods or services, the first thing you want to do is have the trademark search done. That allows you to figure out who's got something similar that may interfere with your trademark application. And you've got to look kind of everywhere because in addition to federal level trademark rights, which is, you know, the big umbrella, states also register trademarks as well. And that would protect a brand within the state. And that might be fine if you know that you're operating fully within your state. You might not have a need to seek a federal registration. Again, it all depends on what your business is and what your plans are. But with that being said, a trademark search will alert you to whatever's out there. It may not be an issue, but it's maybe something that you have to have on your radar. It may be something that's a little too similar, and then you may have to go back to the drawing board and say, okay, let's find something that we think we can clear the federal trademark process with. So again, I think it's also important to say that in determining your branding, it's important to be flexible in case you do run into another entity with a similar name or that could cause some kind of confusion that would put your application in jeopardy. That's why the trademark search is so important. So once you've done a trademark search and you've determined that you want to go forward with your trademark application, this is an online system. The USPTO has their own database, their own registration system. So you go in and you have to provide them with your trademark, and it could be just words, it could be logo. And determining whether you want to go with a word or a logo, again, it depends on how many competing marks might be in the space, what you're using it for. Excuse me, there's a lot of considerations there at that point as well. But let's just say you want to trademark just a simple word that represents your brand. Then you'll have to determine if you're going to file what's called a 1A application or a 1B application. So I get asked a lot about people who are in the startup phase of their businesses. I have a brand name, I want to protect it, but I'm not ready to put it out there. What do I do? So that's what the 1B application is for. That's an intent to use application. So you can file that application and even get it to the point where it's ready to be approved, even if you have not yet released it to the marketplace. There's an extra step in that, meaning that they won't finally give your registration until you show that you've released it, but at least it's getting you started and it's giving you a certain level of protection while you're still in the planning phases. And by a certain level of protection, I mean that filing dates can be important. So if you're filing, say you filed on July 1st for your trade name, and then someone filed a very similar name on July 30th, they're going to look at your application first. They're going to judge your application first before they look at theirs. So it's really important to, make sure that you understand that even if you aren't ready to put that, to release that brand, you still have a vehicle where you can get some protection in place. The other application, 1A, is when you're already using your mark in commerce. And so you don't have the extra step of having to show at a later point that you've released it. So what you'll have to do, you show them exactly how you want the trademark name or logo to appear. You have to create a description of goods and services. So if you have, I don't know, going back to the book example, if you're just writing books under this brand, you would just say books. It could get way more specific than that. It could be more general. Again, this depends on what your business is, and it also depends on what's going on in the pool of maybe similar names in the trademark space. It's a very important, a lot of applicants don't pay enough attention at this stage and end up with some issues later on down the road. You also have to submit what's called specimens. So specimens are examples of how you've used your trademark. So that could be, if you're selling a service, that could be your website, showing the name in connection with the services that you're offering. If you're doing a clothing line, for instance, that would be showing like the back tag, having the logo, showing your merchandise tags, having the logo, showing also like the website with your clothes being offered, with the branding. So there's different types of specimens that are acceptable depending on what the good or service is. And again, that's why it's helpful to talk to an attorney about what the right specimen is. Again, I've seen applications be initially refused because the specimen was incorrect. So you want to be mindful of that. So say you've got all that together, you submit your application. What's next? So the USPTO is saying that it takes about 3 months for your application to be pulled from the queue of applications and assigned to a trademark examining attorney. What I'm seeing with my clients is that it's closer to 6 months. Today, I just got notice that an application I put through for a client was looked at by a trademark examining attorney. We filed it in February. So there's a backlog. So even though you see these times, just you got to plan for at least a year, maybe 18 months in this process. But again, that's why your filing date is important, because that, secures your spot in line. So once it's assigned to the examining attorney, it won't be long before you hear back from them. If everything is fine, they will recommend your application for publication. If there's something wrong, they're going to issue what's called an office action. And that's going to be a letter listing what the problems are, if there's something you can do to fix it, and what the next steps would be if you were able to fix it. You have 6 months to respond to the office action. Common reasons for an office action would be, say, there's another application before you that has a name that's similar. And again, you can't, because of the way the queue is set up in the backlog, you may file an application after doing a comprehensive search, but you may still conflict with the application that has not yet been processed. So it's not an absolute when you're doing your trademark search. I have to point that out. It may be something like that. It may be that when you did your description of goods and services, you threw everything in there, but what that did was make it seem like, okay, you actually need to be paying for 3 international classes instead of 1. So you would have to separate your identification of goods and services and then pay the related fees. Sometimes your trademark is not strong. That's why, again, having an attorney work with you to develop what would be a strong and competitive trademark application is helpful. If your application is too descriptive or too generic, it's going to get kicked back. The more artful and suggestive that your trademark is in association with your goods and services, the more likely you're able to get that application through. There's also something called the Supplemental Register. So if the trademark examining attorney feels that your application is not strong enough to get on the main or principal register, it will allow you to go on the Supplemental Register. So that gives you close to all of the advantages of a federal trademark application, but it wants you basically to prove that your brand has value or that your brand is strong. So you have to wait a few years. And if you're able to prove that, then you can have your application moved to the principal register. Again, I tell my clients to not be discouraged if that happens, because you're still getting some level of federal protection. So again, you get the office action. If it's something that you can fix, you have to respond to the office action with whatever their recommendations are. Sometimes it's not something that you can fix. Sometimes it's just not a strong application, and that's where the road ends. If you're able to get to the next step, that's called publication. And what that is that the trademark office will publish your trademark in what's called the Official Gazette. It's a weekly publication that lists all of the trademark applications that are getting ready to be approved. This is important because it fulfills a notice requirement. This is putting everybody on notice that, hey, I've applied for federal trademark protection. If you got an issue, now's the time to speak up. So there's a 30-day period from that date of publication where somebody says, oh, I've been using my mark for 20 years and it's competing or it's going to be an issue. They have the chance to speak up and to let you know that there's an issue. If there is an issue, that's not necessarily the end of the road. You can always work with the third party to come up with consent agreements where you agree to, okay, allow this trademark application to go forward, but you're not going to prosecute, them later for infringement. So there are different vehicles that you can go still even at that point to get your trademark application through. If publication goes smoothly, then you're on to registration. And then from the period where the publication ends to registration is normally about 3 or 4 months. And then you'll get your certificate in the mail and it'll show up on the site as registered, and then you're done. And then again, well, I haven't said this, but what's also important is that your work in protecting your trademark doesn't end at trademark registration. It's still up to you to protect your brand. If you allow other companies to compete in your space and dilute the brand, that doesn't that doesn't bode well for later on going to court and suing. You have to be vigilant about your brand as to the extent that's feasible. So again, protection is an ongoing thing, and you want to have mechanisms in place where you can be reasonably aware of any infringement if it's happening. Okay, I think that was all that I had prepared, but if anyone has any questions, I'm happy to answer them for the next 10 or 15 minutes or so.
Well, this has been some valuable information. We do have a question in the chat. Alethea actually just had to jump off, okay, but she did want this question answered, and as well as your contact information. So her question is, she's interested in whether she needs to trademark the logo or the name for her studio. And then also if you help prepare liabilities and waivers.
So the first answer, the typical lawyer answer, which is it depends. It depends on your goals. It depends on what's already out there, what the name of the studio is and what the space looks like. A trademark search helps to determine that. So that would be the first step, is to evaluate the name. If it's strong enough for a trademark, then we move forward to seeing if it's advisable to go one route over the other. I will say that generally a word mark, where it's just the word, is stronger because it doesn't matter what your logo looks like. If those words are there, then you're protected. But again, the space may not allow for that. So we have to, evaluate both. The second question about liability and waivers, the short answer is yes. What we're talking about, the nuances, it depends. So if we're talking about, and it's also state specific. So in Virginia, you cannot get out of liability for like gross negligence or for negligence. You can write it there, but the courts won't enforce it. COVID waivers, I've had a lot of, that's something that's really important now, or very relevant now. We don't have case law to really show us what that looks like. The courts have backed up like at least a year for other things. In DC, it's 2 years. So we don't have a lot of case law, but precedent says that, you can't really, get yourself completely out of a situation just by putting waiver language there. It may be certain language that can help. There's something called assumption of risk that is the other side of the coin, where, it's like if you go to a theme park, well, the person there that purchased the ticket is assuming a risk that, hey, if I get on a ride that says, if you have heart problems, don't get on there, and I get on there anyway, I have to assume the risk of any injury. So there are different vehicles that we can use to provide some level of protection, although depending on what you are trying to create a liability waiver against, it may or may not be possible depending on the state that you're in.
Gotcha. And so if she wanted to work with you on something like that, then she can definitely reach out and schedule a consultation and see if that's something. Awesome.
Absolutely.
Awesome. Are there any other questions? You covered so much, so very well. Are there any other questions from those in the room?
Hi, Stephanie, and hi, Lita.
Hi.
Thank you so much. This has been so helpful for me. I do have a question, and it's rather specific, but I was wondering if it's possible, I guess for an example, like I used to work at a university or several universities, and so I like created a syllabus or created trainings, and so I'm wondering, does the university have ownership over the things that were created, even if I guess it was my technically intellectual property, or do you know how that works? Or is there probably somewhere on a university page somewhere that's like any work that was done here belongs to the university?
So language like that would be going into what's called work for hire territory. So generally, if you create it, it's yours, but in certain employment contexts, that would trigger work for hire. So if you have any agreements with the universities, you would first look there to see if there's any language regarding any work product that was created during your tenure, and whether the university was trying to assert ownership. So that would be the first place to start.
Okay, thank you so much.
You're welcome.
Awesome. Anything else before we wrap this up? Well, this was very, very helpful. Definitely even thinking about as an author and some of the, contributors and everything that I've had in my books. So I will definitely be looking in more detail with that. So I appreciate it. Of course, your contact information. So if you're able to put it in the chat as well as say it for those who will be watching this also on the playback. I am pretty sure, definitely sure that they will be reaching out with wanting to get some time with you. So if we could get that.
Okay, I'm putting it in the chat, my email address in the chat.
Okay.
And also say it. So best way to reach me initially is through email. And my email is sthomas, THOMAS at sktlegal.com. Again, it's sthomas at sktlegal.com. And I'm just sent
there we go
in the chat so everyone has it. Yep.
Awesome. Well, Stephanie, thank you so very much for taking your time out, giving us a really good explanation, some good understanding. As I said, I know folks will be reaching out for just further, conversation around these things. But again, thank you so much.
Thank you, Lita, for having me. And thank you also for providing this space for business owners and entrepreneurs to get together. I think it's so important to have that kind of community. So I'm thankful for the opportunity to come in and just share some insight that will hopefully benefit everybody in the group. So thank you for that.
Awesome. All right. Well, you all, once again, thank you, Business Crossing Network. Of course, the website, Business Crossing Network, and be sure to check there for other future workshops, trainings, and resources that we have for you all. And once again, thank you. Have a good night.
Bye.
Bye.